So, good morning, everyone. What are we talking about today on the Trial Alliance? Well, today is issue number 4, and the topic today is fundamental fairness. What does that mean? What does fundamental fairness mean? Well, we grow up in a society in the United States where we expect to be treated fairly, fundamentally fair. We expect to be treated fairly at the base level, right? I mean, these are instilled in us. These ideas are instilled in us as children in our first civics class, in our first government class, as a child in the Pledge of Allegiance, right? And we become familiar with the Constitution, and we understand that the Constitution is about all men were created equal, right? That we are, in fact, fundamentally what we want to be in the United States is fair. Now, that's an ideal. We can argue all day and talk all day about whether or not we reach that ideal or how often we reach that ideal or in what aspects of our lives in society we reach that ideal. But what I want to talk about is the fundamental fairness in the criminal justice system and whether or not we are experiencing or at least adhering that kind of fundamental fairness in the criminal justice system. And this is a very, very important issue. The reason this is important is because this can be used in trial work. Because juries believe in fundamental fairness, right? Citizens believe in fundamental fairness. They believe because that's something they bring to the courtroom. They take seriously the idea that matters that are unfair, things that appear to be unfair, things that can be framed as being unfair in the courtroom will be punished and are ignored. I mean, what we are dealing with here are basic human instincts, right? The basic human instinct is important because if we can appeal to or address or frame our issue inside these basic human instincts, then we will use those basic human instincts to get people to understand our point of view, our story, right? Our point of view about what's going on. And so one of those fundamental instincts is fundamental fairness, right? That the system should be fair, and so it doesn't quite work at the level of the state should be treated like the defense, right? That's not going to happen because that's overridden by another very strong belief in jurors that the state is right and the defendant is wrong. Okay, so you have to be aware of those kinds of overriding issues. What this is involved in is, for instance, on a witness by witness level, right? So when you're talking to a witness or you're talking to a person, or let's say you're just talking to people in society, your boss or somebody you work with or somebody you're trying to sell something to. I mean, if you can point out that what you are doing is fundamentally fair, if you can frame your sale, you can frame your story inside of fundamental fairness, then it will resonate with people in ways that they don't even understand. They don't even get, right? In unconscious ways, the stories will resonate with them. And so what I use as an example in this kind of thing on the jury stand in a jury trial is if you have a police officer who takes the stand, who's a professional witness, and takes the stand and starts saying things that are not written in his or her report. This happens all the time, right? A police officer takes the stand. The police officer knows more about the case now and more about the issues in regard to the case now. And so because they know more about the issues, they want to address those issues, right? They want to address the problems in the case from the jury stand. The problem is that they've written a case narrative, sometimes 2 or 3 or 4 case narratives at this point, temporally associated with the crime, right? So they have case narratives of all the information they got, and the witness interviews they've done, the evidence they've gathered, and they have all of those things written down. Sometime between when the crime occurred and they began the investigation, when the investigation was concluded, okay? It can be a week, it can be a month, it can be 6 months, it can be a year, whatever. It can be 2 days sometimes in a very simple case, and so what you do as a skilled criminal defense attorney is you do 2 things. First of all, you establish with the witness that they've written these documents and that those documents were written as accurately as possible, that they've been trained to write those documents as accurately as possible, right? and that all of the information is in those documents is true. It was true at the time they wrote it, and it's true today. So you pin them on the statements, right? You also then pin them on a statement may have made previously at a preliminary examination. You remember 7 months ago when we were here in the courtroom and we had a preliminary examination and we talked about this case, and you were under oath at that time, right? And you made those statements at that time, right? Statements regarding this case, right? Do you remember that? And those statements were truthful, right? I mean, you were under oath like you are today, right? So obviously those statements are truthful, correct? All right, great. Just making sure we're up to date on that. And then you begin to examine them, right? Cross-examine them on whatever nonsense they told the prosecutor 15 minutes ago that has nothing to do with anything they ever said in any report. You would think that this doesn't happen often. This happens all the time. And it's not like they're bad people, right? I'm not making some fight about police officers are terrible human beings or any of that kind of nonsense. What I'm saying is that it's human nature to fill the gaps in when you know that there are gaps, right? And so the police officers will find out this information. They're like, oh man, the case is good, but there's these couple of problems, so I'm going to address these problems with some information I may or may not actually have, but some information that I'm adding up in my head, right? So I got piece of information A and B and C, and well, that naturally leads to D, so I'm just going to say that, you know what, yeah, well, of course it's D because it's A, B, and C. Well, the problem is that's made up, right? Because from the witness stand, the witness is supposed to testify just as to facts that they know, right? Just the facts that they've got themselves, right? That they've obtained themselves, right? Their present sense impression of the facts as they found them. And so if a police officer goes to make up those kinds of statements, or any other witness for that matter, non-police officers do this 100 times more than professional police officer witnesses do. They'll make things up, right? And so the proper course of action at that point is to talk to them, right? Is to talk to them and say, is to address that, right? To confront that inconsistency in a way that's reasonable, not in a lawyer tricky way, not in a, ooh, I got you now, man, you're crazy way, but in a, you know, we all know as trial attorneys that you have to draw someone's attention to the inconsistency first. Well, do that in a way that's not sort of rote nonsense, right? Well, do you know on 6 months ago when you made the statement, you made an inconsistent statement. I'm going to give you an opportunity to say, nah, that's nonsense, right? You just say, whoa, wait a second. Did you just say this, X? Because I believe in that statement we talked about earlier, you said B, not X. And let them talk about it. Ask them why. Let them run their mouths, right? I mean, once you get somebody making up stories, all the excuses in the world don't matter, because what you're appealing to the jury is to the fundamental fairness of making the same statements, of not making things up. Now, this requires that you develop fundamental fairness in jury selection. It requires that you develop the idea that a violation of fundamental fairness by creating new stories when you get on the stand for the sole purpose of convicting the defendant is grossly unfair and should not be done. So it requires a setup, right? But once you set that construct up and you have the jury understanding in their hearts this idea, if someone gets on the stand and they make up this new story, it is incredibly destructive to their testimony. More so than you can imagine, if done properly, if done with the right constructs, the right metaphors, done in the right way, the construct built in the right way in the beginning, and then to have someone step outside of that box, right? So inside this box of fundamental fairness, and they step outside of that box of fundamental fairness. And juries will punish them for it. I've seen this happen. I've experienced this. I've acquitted people with witnesses that get up, the victims get up and make up stuff on the stand, and they just aren't believable when they do that, right? And so talking about that fundamental fairness, from a jury perspective, it's also applicable in our lives, right? In our everyday life, right? That we require fundamental fairness from the people in our lives. And the people in your life require fundamental fairness from you. And so the truth of it is that we have to stay in that box as well, right? I have to exist in this fundamentally fair box. This box of the equal treatment of my children, the equal treatment of my employees, the equal treatment of the people in my life, right? Because if I deviate, if I make stuff up, if I become arbitrary and capricious in my treatment, then I'm going to be punished for it, right? Then I'm going to be held accountable, held to account for that inconsistency. And so today's message is, where am I being fundamentally fair and where am I not? Where am I being arbitrary and capricious in my treatment of those people around me and myself? And where can I do that better in the courtroom? That's all we have for today. You guys have a great rest of your day.